Their patents suck. The problem of patent trolls, part 4. I'm Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please like, follow, and share. So one of the problems I discussed with troll cases in the last video is they tend to involve patents with claims that are very, in many cases, overly broad relative to what is actually taught in the patents. Another problem that occurs in these cases is that there is a huge discovery burden mismatch between the troll and the defendants, because the defendants are making and selling products. The trolls have no products. It's usually a company just on paper with maybe a couple of officers and usually some dummy office somewhere that nobody goes to, and there's nothing. So there's no discovery to take of the troll, but the troll has tons of discovery to take of the defendants. That discovery is extremely burdensome and extremely painful, and it creates leverage for the trolls to coerce a settlement out of the defendants, simply because once they get in the case, they have that leverage from the discovery process and its inherently burdensome nature available to them. Now, I think the way this really needs to be policed is in the complaint and the initial infringement contentions, and really scrutinizing them to make sure that the trolls have actually stated a legitimate case, legitimately established sort of probable cause for infringement. Because in some of the cases I've been in, they create these claim charts where they parrot the claim language and they will put an excerpt of a manual or some public document from the defendant in there, and there will be almost no relationship, or very little relationship, or at least a tenuous one, between the evidence, which is from the client's documents, and the claim limitation at issue. And if these allegations aren't scrutinized, then the case goes forward, and then now they can use the discovery process and inflict the pain that is involved with it. And some people will settle just because patent litigation is so burdensome. And so different judges to different degrees will hold the troll's feet to the fire in terms of saying, have you really shown that there is any likelihood of infringement here? You don't get to file a patent lawsuit to get discovery to see if you have a case. You have to show you have a case first. You don't have to show the entire case or lay out all your evidence or cover everything, but you actually have to show some prima facie evidence to show all the claim elements of at least one claim are present in the accused product. And I think making sure that the initial infringement contentions or the complaint establish that is really critical for helping to deal with this imbalance. So at least if the troll does get to conduct discovery, it's only after they've really established that there's likely a case. Anyway, I hope that helps to keep you out of trouble, and I hope to see you here soon.